I'm here today with Bill Smith, who is an attorney who represents a number of worker comp cases. Thank you for being here today, Bill.
Thank you.
First, I wanted to talk to you about your thoughts on the current workers' comp system. What role does it play in employment and for individuals, and what's your current opinion of the system we have in place today?
You know, every system can be improved, but our South Carolina workers' compensation system works very efficiently. Overall, it's very good.
Right now, there are a number of groups that are urging lawmakers to put in place a number of reforms, and this issue came before the legislature last year, and it's coming before the legislature this year. I wanted to get your thoughts on a few of these reforms that were put in place by examining last year's bill, which is very similar to this year's bill. The first reform I'd like to talk to you about is the Tiller v. Healthcare, National Healthcare Supreme Court case. There is current legislation right now that wants to peel back that decision and kind of take out of place the current practice that we have today, where we're able to have non-expert testimony in current workers' comp cases. What is your thoughts on that reform, and why shouldn't it be passed?
You know, the Tiller case really didn't do anything to change workers' comp in South Carolina. Tiller was decided in 1999, if I remember correctly. And all Tiller says is that the Workers' Compensation Commissioner can consider non-expert opinions. You can consider the experts, you can assign weight to what the experts have to say, you can consider the lay testimony, and you can consider circumstantial evidence in deciding the workers' causal connection in a workers' compensation case. So Tiller really didn't change anything. There's all this hue and cry out there from the insurance community about Tiller. But if you look at it, like I said, I think Tiller was decided in 1999. It's had no effect on workers' compensation insurance rates. Since 99, workers' comp premiums have gone up. Workers' compensation insurance rates really have not gone up very much. So Tiller's had a negligible effect. And it's not something that needs to be tinkered with. I can talk a little bit about rates versus premiums if you like. But a workers' comp insurance premium is made up of two parts. The first part is what we call lost costs. Lost costs are what is actually paid to an injured worker: the weekly disability payment, the permanent disability payments, and medical care. Those are the hard costs that go into a workers' comp rate. But there's another part of the workers' compensation rate, and that is called the lost cost modifier. Since 2000, the actual lost cost part of rates, or the amounts paid to injured workers in South Carolina, has gone up very small. In fact, in 2003-04, the amount of indemnity payments to injured workers went down. The number of claims filed has gone down, but premiums have gone up. The lost cost modifier used to be regulated by the South Carolina Department of Insurance. They stopped regulating that some years ago. Since 2000, the lost cost modifier has gone up 200%. And the employers are feeling that out there. But it's not because of what's paid to the injured worker. It's because of what the insurance companies are doing to them. And that is one thing that does need to be changed in South Carolina. We've got to get the lost cost modifier under control and regulate it again.
Another thing that a lot of groups are pushing for in reform is the second injury fund. A lot of groups want to see this fund eliminated or drastically reduced in size. Can you give me any thoughts on why we should keep the second injury fund at current levels, or why we should keep it in place at all?
Sure. The second injury fund has been in place in South Carolina for some 30, 40 years now, and it's worked well. It has given employees with a disability a good chance of getting employment or maintaining employment. It has given employers a break. It spread the risk out for employers if they hire someone or maintain someone in employment who has a pre-existing injury or pre-existing disability. You know, if you look at an employer that has invested a lot in an employee, this got this experienced employee that they've had for a long time, and he suffers an injury, they're concerned that if they bring him back to work, he may suffer an injury again. Well, the second injury fund allows them to do that without much concern, because that risk is not going to be borne solely by them. It's spread across the entire market. So the second injury fund works. What has happened, we've gotten an unintended bad benefit from what was intended good legislation. In 2003, our legislature eliminated the unknown condition. And I'll try to explain that just a little bit. Prior to 2003, there were two ways to qualify a claim for second injury fund reimbursement. The first way was if you hired someone or you brought someone back to work, you maintained them in employment with some pre-existing condition or pre-existing injury that you knew about. And you knew about it when you hired them, or you knew about it when you brought them back to work. Then if they suffered a subsequent injury, and that subsequent injury combined with the previous problem, then you could qualify the claim for second injury fund reimbursement. The other way to do it was if you had an unknown condition. If you had a condition that was, somebody had pre-existing diabetes, they didn't know it, or some kind of condition like that, and then they got hurt, and those two conditions combined to make the disability substantially greater. Well, the legislature eliminated the unknown condition, which was the majority of claims. So basically what they did was they eliminated a whole class of conditions from being able to be reimbursed under the second injury fund. Well, that's great. That should make the second injury fund assessments and everything go down. But what happened was the insurance companies were aware of this deadline. They knew that the unknown condition was going away. So they brought in people, they hired people to mine their files to find every claim that might possibly qualify as an unknown condition. They filed all those claims. Well, there were hundreds, thousands of claims filed. And as a result of that, a lot of them qualified, and it made the assessments go way up. Well, that bubble's over. Those claims are gone. For, I think it was 2006, the number of second injury fund claims filed has gone down something like 47%. Assessments have gone down. So this big thing with the big reason for the cry for change with the fund is now over with. There's no need to do it now. The other thing is NCCI, the National Council of Compensation Insurers, which is the licensed statistical and rating service for South Carolina, actually did a study on what happens if you eliminate the second injury fund. Well, they found that if you eliminated the fund, premiums were going to go up 17%. Rates were going to go up 17%. Well, that's what they're projecting. That's before you even throw on the loss cost modifier. So it's not like the claims go away. They just get shifted. And so, and the result of that shift is